is migration rights, right to travel, food, and prior notice in the light of Article 21 and the migrating labor. So, let's try to understand the situation a little bit. There was a time. I'm audible to everyone. Everyone can hear me clearly. Okay, so let's try and understand. There was a period in 1975 that our country went through an emergency of a different kind. Of course, how we understand that time, most of you would not be born then. In fact, all of you would not be. Even I was barely born. But we have read about that period. We've heard about that period. And we saw that that was a period when all fundamental rights were suspended with the proclamation of emergency. In fact, the right to life was also suspended with the proclamation of emergency, and the situation was of such turmoil and such complete oppression of fundamental rights that anybody was picked up from anywhere. People were picked up from their homes, from their offices, from their colleges, from restaurants, from parks, from just roadside. People were picked up. They were not informed why they were picked up, and without any cause, without any reason, without any justification, people were put in the jails. Now, like all times, that was a time when liberty was completely jeopardized and completely threatened. Life itself was threatened. So obviously, people who were detained, them and their families, filed writs of habeas corpus across the high courts in the country. And in fact, it was 9 high courts in one voice. They said that, other fundamental rights can be suspended, but right to life can never be suspended during an emergency. And that judgment, ultimately, those 9 high courts, that view came up to Supreme Court, and that came up for consideration in the celebrated judgment that we have all come to know as students of law as ADM Jabalpur's case. Now, ADM Jabalpur's case was that case where the Supreme Court was constitution bench consisting of really respected judges of the Supreme Court was considering whether right to life and liberty can be challenged. Article 21 can be suspended during an emergency. And in ADM Jabalpur's case, overturning those 9 high courts, the Supreme Court said that the right to life can be suspended during emergency, and it has been so rightly suspended by the proclamation of emergency. This judgment has been not just criticized in masses and by citizens, by successive generations of citizens and academia, but even two of the stalwart judges who were part of the bench after their retirement regretted that judgment. And we saw that, in fact, that this judgment, ultimately, you would have seen in the privacy judgment of the 9 honorable judges in Puttuswamy's case, just 3-4 years back, reversed ADM Jabalpur. Though ADM Jabalpur was not directly in question and in challenge in that privacy judgment, but the majority judgment deals with the ADM Jabalpur judgment and says that that is no longer good law, and it cannot stand as good law. Now, I have just taken you through the judicial journey of ADM Jabalpur. I think this case is also a very beautiful example of the basic principle of institutional checks and balances that exists in our constitution. Mostly we see that the judiciary is there to check the actions of the executive, the actions of the legislature, to see that their actions are within the contours, within the parameters of the Constitution of India, because Supreme Court of India is the chief interpreter of the Constitution, and it is their job to keep the executive and the legislature within the constitutional parameters. But what happens when the Supreme Court fails? So this is an example of how our constitutional mechanism provides a system of checks and balances, that when the citizen needed Supreme Court the most, we have to appreciate that was a time of no medical pandemic it was not a time of any economic, economic issues or economic depression. It was not a time which concerned any health or even any external aggression. India was not facing a threat from any of our hostile neighbors or any of the other hostile sovereigns. This was a case this was a time which was inflicted on the nation by the political high class, which enjoyed the brute majority and had the privilege. And this actually, if you go back, it actually stems from the judgment of Indira Nehru Gandhi versus Raj Narayan, when the election of the premier of the country was challenged. That is the backdrop in which this exercise was done of emergency. So it was a pure violation. It was a pure suppression of civil liberties. It was a police raj. It was a time of extremities, and it was a time when people really needed access to justice and rule of law the most. And though other fundamental rights could have been suspended, but right to life being suspended and that being upheld up to the highest court of the land. In fact, high courts said otherwise, but Supreme Court reversed it. So for Supreme Court to let down its citizens was actually, the succor was then provided by the 42nd Constitution Amendment, because the legislature then came up with the system of check and balance allowed the legislature to pass the 42nd Constitutional Amendment Act, which made right to life and liberty, Article 21, as inviolable, as something that was sacrosanct and could not even be suspended during any emergency. So I had to take you through this journey because often, in today's date and time, we as students of law are confronted with these questions, and there is some kind of a comparison made with the times that the COVID-19 times that we are living in right now, with the times of the emergency, where we saw rampant and large-scale violation of fundamental rights. In fact, that having been said, now bringing you back to the topic, to the migration rights. See, the Constitution, Article 21, of course, is one of the most dynamic articles of the Constitution of India. We have seen that Article 21 has been given such expansive meaning through the years. It has been interpreted to, the interpretation of Article 21 has been, it has been such an interesting journey for any student of law to follow. Initially, it had a very constricted interpretation that was given to it. We saw in A.K. Gopalan the theory that fundamental rights are not, when you challenge a violation of fundamental right, you could only challenge one fundamental right, because fundamental rights were like isolated buckets and they were not interdependent on each other. But then this theory was shattered subsequently in the Maneka Gandhi's judgment. Now, Maneka Gandhi's judgment is actually a very important judgment for Article 21 and Part 3 of the Constitution for two reasons. See, the first point is, I'll just briefly take you through the facts. Maneka Gandhi's passport was impounded by the passport authorities, and she challenged that in the court of law. And till that time, till the judgment of Maneka Gandhi, the right of Article 21, which protects life and liberty of the citizens, it was it was understood to mean that it cannot be taken away unless without procedure established by law. That is the pure language of Article 21 also. In fact, it's not just available to citizens, it is available to non-citizens also. So it's a single line article. All that it says is, no person shall be deprived of his life or personal liberty except according to procedure established by law. By contrast with Article 19, which is available only to citizens, the freedoms which are available only to citizens, our fundamental rights have different kinds of rights. Some are available only to citizens, some are available to everyone in India. Now, Article 21 is the right which is available to everyone in India. And the way it was understood up to Maneka Gandhi's judgment was that right to life and liberty can be taken away, can be curtailed, can be restricted if it was done in accordance with procedure established by law. That is how, that is how we see that the under trial or accused persons, after going through the process of trial, after going through the process of investigation, they are incarcerated, they are sometimes condemned for life. Their life also can be taken away by capital punishment, and there are several other reasons, but that is procedure established by law. So when Maneka Gandhi's challenge came, the simple no-brainer response that was given on behalf of the passport authorities was that, well, there is a procedure written under the Passport Act and the rules, and we have done it strictly as per the procedure. And since the procedure is there, it is there in the rules and regulations. We haven't violated Article 21. This is strictly within the contours of Article 21. Maneka Gandhi, as a citizen, had also challenged violation of the other rights because Article 14, Article 19, and the first aspect of Maneka Gandhi's judgment, it is a beautiful judgment for all of us students of law to follow. And the first point was that the fundamental rights are not like isolated islands. They are interconnected, and a cause can be brought in that on the ground that it is violative of even two or more fundamental rights, and that will be examined. And even in alternate, that can be raised. In addition, it can be raised. So the theory that fundamental rights were independent, isolated islands was done away with. The second aspect that was brought in the Maneka Gandhi's judgment was the due process clause. Now, this due process clause is something that has been brought in from the American jurisprudence, and so it was interpreted to say that under Article 21, to take away life and liberty, it should not be just mere procedure of law, but that procedure itself must satisfy the due process, which means that process has to be fair, just, and reasonable, and it cannot be arbitrary. So this was the test that was laid down in Maneka Gandhi's judgment, that it has to follow due process, in that procedure itself has to be fair, just, and reasonable, and non-arbitrary. Now, thereafter, we saw Article 21. In fact, there was another limb of interpretation of Article 21, where we saw that Article 21 was interpreted to mean everything that is necessary, not just for our existence merely as an animal existence, merely as an existence in a physical form, but for our existence as a human being. So what was read into Article 21 was everything that is necessary for a human being to live the life of dignity as a human being, is part of Article 21. That's why we had the entire environment jurisprudence being laid down under Article 21. We saw Supreme Court taking cognizance of, in fact, the entire public interest litigation is coined under Article 21, because public interest litigation is something that is a departure from the classical traditional concept of locus standi. And classical concept of locus standi is something that is considered as a fundamental principle in all jurisprudence and all justice delivery systems across the world. This is not peculiar only to India. Locus standi means that if I have a problem, I go to court with it. I can't go to the court and say that my friend has a problem or XYZ has a problem. Unless, of course, there's some categories that the person is minor, or in those special categories of unsound mind, or not in a position to come, etc. But the public interest litigations were coined under Article 21 because a vast majority of the population of the country was living in such abysmal conditions, and there was no access to justice. They had no recourse to the court of law for vindication or protection, or even to complain or cry about a violation of their fundamental rights. If public interest litigation would not have been coined in India, it was something which was peculiar to India. And I strongly believe that if it had not been coined in the early 70s, then fundamental rights for a large majority of Indians would have remained a mirage. We can't look at it from the prism of 2020. We can't even look at it from the prism of the last 20, 30, 40 years. We have to go back to the prism, the socio-political conditions that existed in our country in that time. Of course, now, now we have a statutory mechanism of legal aid clinics, and legal aid authorities are existing. And on the national level, under the Chief Justice of India, in state levels, every state has legal aid services authorities, which are headed by the Chief Justices of those states. Then we have legal aid service authorities at district level and even at taluka level. So today, by virtue of the Act of 1987, which was in exercise of the directive principle as prescribed under Article 39A, I think, to provide free legal aid to all its citizens, this regime has been brought in. So today, when PILs have become publicity interest litigations, of course, we all, it leaves a bad taste in our mouth, and it's clear to see that public interest litigations have by a huge majority, they are being done as a matter of routine. They are being done as a litigation churning exercises, and they are done more for some vested right or for publicity interest. I'm not saying all of them, but a large majority of them. But when it was coined, it had a different perspective. So this was also done under Article 21. Then from the environment issues, the entire environment jurisprudence of polluter pays, of precautionary principle, of sustainable development, these trinity principles of environmental jurisprudence, to saving the heritage of India, the Taj matter, the Taj trapezium zone matter, where I continue to, the matter continues. In fact, the judgment came in 1996, but there are some matters that are continuing as continuing mandamus matters. Taj matter is one such matter where I have the privilege of appearing as the Additional Advocate General for State of UP. Also, the environment matters, T.N. Godavarman, which was known as the forest matter, that continues to still go on as a continuing mandamus before the Supreme Court. So, and then we saw cases like Hussain Ara Khatun, which were to make sure that under trial prisoners who were languishing in thousands in jails in Bihar, because they did not have any access to justice and any representation and any money to give for bail. So such prisoners, they had been in jail for such long periods of time that even if they would have been convicted after trial of the offense that they were held for, then they had completed far more period of incarceration than that time. Then to the children who were working in the toxic factories, despite constitutional guarantees of there being no child labor in hazardous industries, even from the beginning. Of course, now we have a much stricter legal regime. So this different varied jurisprudence from women's right of self-determination to choose a partner of her liking, to reproductive rights, to livelihood rights, these have all been developed as contours of Article 21, all inclusive in the dignity of life as a human being. I should also briefly touch on Article 19, because the issue of course, the freedom of speech and expression that we know so much from Article 19, but also the freedom to form associations, the freedom to move about freely anywhere in the country, the freedom to reside anywhere, to choose a livelihood or a service or a profession of your liking. These are all freedoms which are available to citizens of India under Article 19. But what is interesting, what I find interesting as a student of law is that under Article 19, what often goes out of focus is, for most of us, is anything apart from the sub-article 1 of Article 19, which contains all these freedoms. But the rest of the sub-articles have all the all the restrictions that can be imposed, and what are the grounds or reasons on the basis of which those restrictions can be imposed by a law made by the state. Now, the state means it could be either union, it could be state, depending on which list under the 7th schedule that subject category falls in. Now, let me read for you just one or two examples of what are the restrictions that can be laid down under, and what are the grounds on which those can be laid down. For example, under Article 19, Sub-Article 2, for the freedom of speech and expression, which we all understood very, very, very strongly, and it is a very it is a right which we enjoy and cherish as Indian citizens a lot. This can be subject to reasonable restrictions. On what grounds? In the interests of sovereignty of and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation, or incitement to an offense. These are all the grounds and all the causes on which reasonable restrictions can be imposed on our freedom of speech and expression. Then the freedom with regard to move freely anywhere in the territory of India, and also to reside anywhere and settle in any part of the territory of India. This is subject to restrictions which could be either in the interest of general public or for the protection of interests of any scheduled tribes. Now, for the protection of interests of general public makes it very clear that it is not individual right that that gets primacy. If there is a tussle between right of one person whereas collective right, then it is the collective right of general public that has to triumph. In fact, it is so clear. The current Chief Justice of India said that, in one of the speeches, he very interestingly and very simply put, he said that your right to move your hand is guaranteed under the Constitution, but your right to move your hand ends where my nose starts. In exercise of my right to move my hand, I can't be hitting your nose, and similarly, you can't be doing that. Often we understand these fundamental rights as rights which are absolute. In fact, even the rights which are not constrained by these provisos or restrictions which are prescribed in the Constitution, in those articles itself, fundamental rights, or for that matter, any right, cannot exist in absolute terms. It cannot exist in vacuum. It cannot exist as a entity which is free from all outside influences. We often understand also fundamental rights to be rights which are available to us against the state. That is correct. That is the correct understanding of part 3 rights, which are all fundamental rights, and they are rights available to citizen against the state. But they are also rights which are available against the collective citizenry, and they are also confined or restricted by the considerations of general public good of the citizenry. Let me bring you to the specific points that we are saying in our topic. The specific right is right to travel. Of course, our right to travel has been completely curtailed. We can't roam around. We can't move about anywhere we like. The states have put in these barriers. What to talk about? Going to different states. I live in Delhi, and I see NCR is one contiguous region. It has always been, ever since it was conceptualized and it was made. We have people, thousands and lakhs of people who are living across NCR and working across NCR. But every day they travel from one part to other. There are e-passes. Most of them get rejected. Some are allowed. It is extremely difficult. And if people are in containment zones, it is a nightmare. I mean, all of you, most of you are from Pune, I understand. So Pune itself was declared as a city which became a city which was a containment zone. So that city, you have seen the kind of restrictions that have been there. Of course, we have restrictions. We can't go to our favorite restaurants. We can't go to the libraries. We can't go to gyms. We can't go to movie halls. There's Pradyuman talked about, I mean, dying of boredom. I think I will urge all of you to think that if boredom is your biggest problem, I mean, if all of us have our biggest problem right now in the COVID times is boredom, then we are very, very lucky. I want all of us and all of you students to introspect and think about it. You know, the doctors, the health workers, the first responders to the COVID-19 across the world. And this is, you know, interestingly, we have, I mean, fortunately or unfortunately, the whole humanity is in this together. So we have seen the suffering of humanity across the world. We have seen how the health workers and these PPE kits, I have read articles about how these PPE kits are being, initially when the COVID started, India did not make even a single PPE kit. Of course, now the production capacity has increased a lot, but these PPE kits are worn by doctors and they are a one-time use kind of a kit. So if you open it, then it does not seal. And if it does not seal, then it is not a protection against the virus. When the health workers, the caring staff, the doctors who are in COVID duties and COVID wards, when they are wearing these PPE kits, you know, they can't eat for the 8, 10, 12 hours that their shift is. They have to wear adult diapers because they can't open their kits. There has been shortage of these kits, so they could not afford to use 2 kits or 3 kits in one shift. They had to use single kit, PPE kit through their entire shift, and they were wearing adult diapers because you have to answer the call of nature. You can't, at least you can't go without urinating. So that is the condition that the first responders are going through. Look at their families. Look at the kind of, you must all have seen, like me, the images from America, where graveyards in New York, graveyards are being uh, dug in the middle of the city because they are falling short. The congregation of dead bodies in the trucks, which are supposed to be transport trucks to carry food items which required a cold chain, those trucks are being used, and human bodies are being lifted by forklift. There is nobody to give to perform last rites for a lot of these patients also. I mean, the ultimate dignity in death is also illusory for them, because the rest of their family is either positive, so they are in hospitals, or they are quarantined, so they can't go. Such gruesome, such grim images of the health workers and first responders on one side. Then look at the economic impact of this. After all, the walking of the migrations of the migratory workers, and of course they are daily wages, that is an economic implication of this. uh, but when there are diverse competing interests, uh, we could not have, as humanity, as nations, as societies, we could not have put our economies on a greater premium than survival. That is why economy became the second fiddle, till we were able to ensure that we had sufficient infrastructure available, sufficient hospitals, sufficient COVID wards, sufficient COVID beds, ventilators, PPE kits. We had sufficient infrastructure to deal with the pandemic that of course nobody had an idea about. So that being the situation, if we have, and we see that people have lost their jobs. Of course, the daily wagers are hardest hit because they don't have any security. But everybody has an impact. Financial impact and economic impact is something that nobody has escaped. That situation, of course, is different. The impact is felt differently for different people, because because the labor have to go back. They felt compelled to go back to their homes. They were, of course, the shelters were providing free food, but for how long? And the kind of conditions which were there, and everybody wanted to feel the security of their homes, and the security and surety is something that we all look for as human beings, and that is that is what the migration workers were also looking at. The daily wagers who migrated basically were looking at. Now, coming to the aspect of food, uh, yes, we all have fundamental right to food. None of the aspects of the topic that we have chosen today can be denied as a fundamental right under Article 21. A lot of it is additionally guaranteed under Article 19, but let's take it from a 21 perspective, because 19 is available only to citizens, like I pointed out. Now, right to travel, right to food, right to habitation, right to prior notice is also a kind of a fundamental right, though it has not been laid down as such under Article 21. But now I urge you to go back to the jurisprudence that I was speaking about of rights existing in absolute terms. If the rights have to be restricted, they have to be curtailed in some manner for the larger public good, because we have a pandemic that is scaring us. We have a pandemic that has not given us a prior notice. We have a pandemic that has not cared to look at which part, or just particular geographies that it has attacked. This is an invisible enemy, which has shown no mercy, and its impact has been felt, and in fact horrifying impact has been felt across the countries, and wherever there are urban centers where there are more people, because this virus is supposed to be 100% infectious, though now we are realizing and understanding that the mortality rate is not very high. But I don't want to touch too much at great length the medical aspects of this. I just touch the basics for us to understand that we need to have a balance. And there's a passage that I took out from Palkiwala's book, which contains his greatest lectures. Of course, we all know Palkiwala has been a great doyen of the bar. He was somebody who was at the top of the litigation career, and he was involved in all cases of constitutional importance which were argued before the Supreme Court for 5 decades, from the beginning of the Constitution to 5 decades thereafter, 50 years thereafter. So his impact on the jurisprudence in our country has been humongous, including including the fundamental rights case of Keshwanand Bharti. He was instrumental in that jurisprudence having been developed and declared by the Supreme Court of India. So one of his lectures in the University of Calgary in Canada on 11th November 1990, which he was, the topic of that lecture was human rights and legal responsibilities. He talks about the correlation between the legal rights and legal responsibilities. And there's just a small passage that I'd like to read to all of you. Palki, of course, this whole lecture, I'll commend to all of you to read the whole lecture. This is a great time for all of us. We have so much of time at our hand that whoever have been inspiring and guiding figures for us in the profession that we are choosing, in the subject that we like, we should read their thoughts, their life journeys, and the kind of struggles that their life journeys have been. It has helped me. I have enjoyed that a lot during the lockdown. That's why I'm recommending. So he says, making the comparison between the legal rights and legal responsibilities, he says, no virtue is absolute, not even freedom. One man's freedom fighter is another man's terrorist. It is true that eternal vigilance is the price of liberty, but it is also true in even a deeper sense that eternal responsibility is also part of the price of liberty. Excessive authority, he goes on to say, excessive authority without liberty is intolerable. When we have too much authority, like in China, we have if you want to search for Winnie the Pooh, you can't search Winnie the Pooh on Chinese internet search engines. Of course, they don't have Google, they have a different thing, but you can't search it there because in some portions of media, they had made a comparison between the Chinese premier and Winnie the Pooh. You all know Winnie the Pooh. It's that beautiful, sluggish, sloth kind of a bear who loves honey and who will do anything for honey, and otherwise he's very lazy. So there were some comparisons made about the body language of the Chinese premier and the body language of Winnie the Pooh. And what happens? The Winnie the Pooh is removed from internet search. You can't search it anymore. And when you search it, it says that this content is removed in accordance with the local regulations. We have all seen that the country which has at least been the origin of this horrific virus that the whole world is grappling with today, the kind of information that ought to have come out. There is, when we talk about as students of criminal law, if we say it's very, very important what has been the conduct of a person soon after the crime has been committed. Often the direct eyewitnesses for commission of the crime are not available, even in ordinary crimes. But what happens is that after the commission of the incident or the crime, what has been the conduct of that person who is accused? Did that person inform the world that there is a virus like this? Did that person share the best practices? Did that person or that nation in this case share all the information that was available? Or when people really started dying in huge numbers in Italy and New York, did the world actually learn about this virus? It is most unfortunate the manner in which this has happened. Anyways, I was talking about excessive authority. I took you there. So Palkiwala says excessive authority without liberty is intolerable. But excessive liberty without authority and without responsibility soon becomes equally intolerable. He goes on to say that while we are commendably concerned with the issue of human rights, we may ask ourselves, are we equally mindful of the paramount need of legal responsibilities? Have we reduced the inalienable rights of man to life, liberty, and the pursuit of litigation? One more line I have to read because it's a line that you as youngsters will relate to very well. He says, liberty has a hypnotizing sound, while unfortunately, responsibility has no sex appeal. I'll repeat this. He says, liberty has hypnotizing sound. So all of us get hypnotized by liberty, while unfortunately, responsibility has no sex appeal. Freedom is like alcohol. It must be taken in moderation. He goes on to say, but of course, we have a constraint of time also. I think I've already gone over 40 minutes. So these are some of the thoughts and some of my ideas and my understanding of this, the problem of migration rights, right to travel, food, prior notice, and migratory labor. And in current times, we can't be looking at an issue in isolation. It is important for us to understand the complete perspective. Thank you for listening to my thoughts. I think we can go on to question answers, Pradyumanji.
Yeah. Thank you so much, ma'am. Ma'am, so basically, my first question to you is whether you talked about liberty and responsibility. So whether the national interest, and on one hand the national interest, and on the other hand the fundamental rights of the citizen, in case they conflict, like one can say that the protection of fundamental rights of citizen are part of national interest. So which shall prevail?
I thought that is exactly what I explained in the last 40 minutes, but let me just recap for you in a nutshell. I think probably you did not, I was not so coherent and so clear. See, right of one individual or fundamental right of a certain number of individuals, if it starts running counter or in counter distinction to the rights of the general public, then That is why I read to you Article 19 restriction. That is exactly why I read to you the aspect that the right cannot exist in vacuum. It cannot exist in isolation. It cannot be that the right of one person it can triumph in at the cost of, at the expense of rights of others. It has to clearly give way. That is the basis of the constitution itself. And this is not and these are not normal times. We have to bear in mind that these are not that is why I took you to the comparison to emergency also, that we were not looking at any medical emergency. We did not have any economic issues. We didn't have external aggression or a war that was impeding across borders. That was a pure violation of rights. There the importance of the rights, duties was was more sacrosanct, but unfortunately the Supreme Court failed us. But today the time is extremely different. This problem is not the kind of problem that the world has ever seen or anybody could have anticipated. Could you have anticipated 6 months back? Any one of you? I mean, not even in our wildest dreams we could have anticipated.
Ma'am, Mansi Desai is asking, almost on a daily basis, we come across instances of poor condition in quarantine facilities. Even when these migrant workers are arrived in their home state, some of them were subjected to quarantine. But the condition in most of these centers continues to be dilapidated and dismal. Wouldn't that also constitute to a serious violation of right to life of those individuals?
No, you are right. I have seen those videos myself. And we have continued to see those videos. I'm not here trying to justify the condition of quarantine homes that were not up to the mark. I'm merely trying to make you understand my opinion and my understanding of the balance between fundamental rights and legal rights and the responsibilities that go with it. You know, yes, it was violation of fundamental rights for those people in the quarantine in quarantine facilities, which were extremely substandard positions. But was it not a violation of fundamental rights for those health workers who were forced to stay away from their family, who could not, mothers who could not hug their toddler children and who could not breastfeed their children who were younger? But we have to balance out. We are a developing country. It's not like we have the best of the resources available to us. We have all the struggles of infrastructure resources, of all other kinds of resources that go with the struggles of a third world country. We are developing quite fast, but we have all those struggles. And we saw what happened even with countries which have supposedly the best healthcare systems in the world. The situations were not hunky-dory or happy even in those countries. Yes, we the situation in our country also has been lacking in many areas, but to see at, when you are faced, when your entire house is burning, and then you want to disregard the burning of the house, but you only want to raise the issue of one point, that I have a doll, my favorite doll, in that room, and that doll is burning. It has to balance out. You can't disregard that the entire house is on fire, the entire society is on fire.
Ma'am, Shesh Tiwari is asking, the Uttar Pradesh government has decided to send migrants to different states only after prior permission by the host states to keep a note of benefits given to the migrants. As you have represented state of UP a number of times, do you see this as a restriction on right to movement? Or is it the state finally taking responsibility for their native citizens?
Well, in my opinion, uh, if you see the way the authorities have reacted and to this COVID, of course, you have to bear in mind that this is something that was unprecedented. This is something which was like fighting an invisible enemy. We were on uncharted territory, the whole world, and so was India. So the authorities, the country, the governments of states, of union, they have tried to do the best with the resources that were available to them. Initially, food was the priority, and it was ensured that food is there for everyone, and everyone, it was not just government authorities, but private individuals, NGOs, everyone taking care of food of the underprivileged people. Everyone was told to take care of their stuff. Then Then we saw a change in policy, and the change in policy is important. See, we are dealing with a very dynamic situation. It's not like we are today in the same situation that we were at the outbreak of the COVID. The situation is very dynamic, both in terms of the spread and understanding of the virus, as also the conditions of the of our own resources, of our own population, and our own authorities' readiness. So the decision was taken for migrants to move back. Whoever wanted to see, nobody has been pushed to go back home. Nobody has been forced by authorities to go back home. These authorities have, everywhere across the country, have only been trying to make their movement as crease-free as possible. It has not been the best of the situations, best of the scenarios. We saw videos, fortunately for us, media was working in our country like the other first responders, and we saw images and videos and detailed accounts of how situation was. Now that migrants have a large number of migrants have either moved or registered to move, Shramik Expresses, etc., are being run. The other issue is now for the economy to start back. If all the migrant laborers are going to come back to their hometowns and not be in those states where economic activity has to happen, and migrant labor has a huge role in the kickstart of the economy, whether it is the construction sector, whether it is industries, whether it is, everywhere, the role of labor cannot be taken away by anyone. Of course, we have a great deal of automation and industrialization that has happened, but still labor is important. So this is the third phase that we are seeing, that now whichever states want to take the labor, which are from those particular states, though I've not followed that decision of UP government at length so far. This is a recent development, but this seems to be the third, the third limb of that action of ensuring that migrant labor, if they want, if they choose, if they if those states who want to take them for economic kickstart, they have conducive parameters and conditions, then it should be facilitated. I see nothing wrong in it for these reasons.
Yes, ma'am. Ma'am, there are a few comments on the role of Supreme Court. Mr. Dushyant Dave has opined, this question is by Rugved. Mr. Dushyant Dave has opined that the Supreme Court has gone into coma in the crisis. Do you agree? Do you think the SC is now reluctant to question the steps taken by the government for that reason? So I'd request you to throw light upon the role of Supreme Court in pandemic times.
So I don't agree with Mr. Dushyant Dave at all. Though I have worked very closely with Mr. Dave, I respect him a lot as a human being, as a senior, but I don't agree with this statement of his at all, because see, that I will urge you to go back to the comparison that I made of the emergency of 1975 and the times that we are living in today. Today, the direction and the and the further course of action, the decisions have to be taken by the experts, or at least have to be guided by the opinion and suggestions of those experts who are dealing with and who understand, who have the competence and the capacity to understand the times that we are living in. So it has to be healthcare workers, doctors, and now that the nation has gone in the second phase of starting economy also, because we have now sufficient infrastructure available to deal with the pandemic. It's not like the pandemic has gone away. We've seen that the numbers are growing. India has not hit its peak yet, so we are on the climb up and we see rising numbers every day. But we are in a position to have sufficient COVID beds, PPEs, etc. So medical infrastructure and other infrastructure has been bolstered across the country by different states. So economy and medical are these two important aspects. See, this time, this COVID-19 time, has not been a time of a suppression or a violation of fundamental rights by the legislature or the executive in a political cloud. This, here, the violation of fundamental rights, if at all, has happened to protect the greater good. It has at the most been a side impact. It has been a collateral damage to protecting the greater good of societies, of states, of nations, and of societies and humanity across the world. So in fact, I'm of the firm view that this is not the time, or these are not decisions for Supreme Court to be making. The judges are experts of law. Judges are not experts in medical field or in the fields of economics, and governance has to be left to the government. Only if the governance, executive, and the legislature, if they violate the constitutional principles, that is the time when the courts of law have to step in. And given the situation that we have seen, I can't, as student of law, I can't fathom any time that constitutional principles were violated in the hunger for power or for political reasons. This has been, if at all it has happened, like I said, was because of the medical pandemic. So and Supreme Court is not equipped to deal with these kind of issues. They're not equipped to take policy decisions. In fact, what does the Supreme Court do? Ultimately, we as students of law, let's assess. When we challenge a policy or a decision of the government or a law made by the legislature or a circular or anything, when we challenge it in the court of law, mostly it is on the ground of being arbitrary, being unjust, unreasonable. That's the due process clause of Maneka Gandhi when I was mentioning. So most challenges are on that ground, or discriminatory or violative of 19, but mostly it is as arbitrary, because it is easy to call everything arbitrary, and that is one very important limb which is available to us. And what does the courts do then? If they find it to be arbitrary, they strike it down. They don't lay down that, no, you do like this, because that is not their job. The only rare time that the Supreme Court of our country actually laid down law, actually laid down guidelines, was the judgment of Vishakha in 1996, when Supreme Court laid down guidelines to curb the sexual harassment of women at workplace. And that also they said, because there is absence of law, we are laying down guidelines, and these guidelines will operate till the law comes into force. Of course, that law came into force after some 17 years in 2013. But in other cases, the job of the court is very aware of, and that is the constitutional mandate for the court also. We can't expect our courts to be doing extra constitutional mandate. Their mandate is to see whether the executive and the legislative functioning is within the contours of the constitutional parameters. If not, they strike it down, and then it is again left for the executive or the legislature to come up with a fresh policy or fresh action on that.
Ma'am, we'll be taking the last question. Mohit Singh is asking, do government have authority to hide information to prevent public panic?
Well, the power, I'm certain, is available under that. No, it's not specifically available, but under the emergency provisions, it would be available. But in India, that's unlikely to happen. See, what the government has curbed and controlled is the fake news. That is why fake news is something that the government has clamped down hugely on, because in the times that we live in, social media goes berserk sometimes with fake news, and it's all over the place. But this pandemic has also shown us that it is so much important for countries to have democracies, to have rule of law, and to have transparency. Because if graveyards are being dug in the middle of the city, then people need to know. You can't have just by way of governmental dictate, directing. If in our time also, in this COVID time also, if people had not participated in the exercise, in the lockdown, restrictions, in all the other restrictions and governmental directions that were coming from time to time, we saw some aberrations, we saw some violations. But please assess, please make a comparison. We are a country of over 130 billion people. So in percentage, the aberrations were less than 0.01% of the population of the country. But in large numbers, the citizenry was complying. And why were they complying? Because information was being shared with them freely, because the fact that COVID is an extremely serious condition was disclosed, people were made aware of that, because news was not hidden, because media had a free hand everywhere. So and it's not just for India. I will urge you to make this comparison for countries across the world, where we have seen robust democracies and healthy democracies being in place. Those countries have done better, and in those countries there have been lesser excesses on the citizens, because citizenry has walked hand in hand with the government policies, because ultimately government is running that. Who is government? In a democracy, a government is of the people, by the people, for the people. We have voted them in power. Because we don't, we as citizens, not everyone can run the country. We need a system, and that system, we have our representatives who run us as a country. So we have put them in power. They are a reflection of us. They are our representatives. And those countries, for example, countries like Sweden, who have placed so much of faith and confidence in their governance and their authorities, have done so much better. Sweden has not seen lockdown to the extent that the world or other European countries have seen. Sweden continues to have restaurants that are open, schools that are open, that have never been shut throughout, because Swedes trust their governments, and they comply with. Of course, they are also a developed country. They have the resources and the means available to live social distance lives, and so in restaurants, the only barrier for them is they can't stand up in restaurants. So bars, you can't stand up, you have to sit down, you have to sit on a table, and you have to maintain social distancing. And by contrast, look at the country which is becoming the next hub of COVID-19. Look at Brazil. Brazil is fast developed into the next hotspot of COVID-19. And the peculiarity of that country is the president of the country there are protests. In India, we haven't seen the kind of protests about lockdown, but protests have happened across the US. They have happened across the developed world. In fact, in those countries, the idea of civil liberties, in fact, we have emulated from them. Their ideas of equality, civil liberties, of dignity is much, much higher. And that is why they were finding it difficult to have lockdown initially, till they actually realized the magnitude of the problem. But even those countries have done it to save lives, because if they didn't do it, then lives would be lost, precious lives would be lost. You've seen the kind of data that has come, that if lockdown hadn't happened, then the number of lives that would have been left would have been lost, would have been humongous. And Brazil, and on the protest against the lockdown, the president of the country is participating in the protest. Though as a head of the executive, he is taking the decision for lockdown, but he's also participating in the protests against the lockdown. Brazil, both the health ministers, the first one resigned. The second one who was brought in, he also resigned. So it is important for us to look at the world, because this is not a problem that we are alone suffering. This is a problem, unfortunately or fortunately, the entire humanity is together in this. We have examples of countries which are strong democracies, which put strong focus and purpose on the rule of law, on democracy, on transparency. And transparency of true facts always gets better recognition and better validation and better implementation of policies. Whereas fake news is the one that actually brings in hysteria or a rumor. Otherwise, the correct situation must be brought out, which most good democracies have done, like India.
Thank you so much, ma'am. I hope that this lecture has been an enriching one, and I hope ma'am has been associated with Think Indian as a part of previous lecture series also, and we'd hope that ma'am joins us in future also. On a thanking note, I would like to thank our national in charge Ganesh ji, national co-convener Shivam ji, Pune convener Rupal ji, state Maharashtra convener Yogesh ji, and our whole Think India Pune team, Rugved, Manasi, Amrita, Asha, Ambalika, and everyone. Thank you so much, ma'am.
Thank you so much, Pradyumna.
Thank you, ma'am.